Good morning. Thank you very much for the introduction. Thank you very much for the invitation. Dear colleagues, dear participants, ladies and gentlemen, I think I will start in medias res, not too much speaking about the context, because I think Katarzyna is the one to hold together all these articles, and she is the one who knows everyone and who knows who was responsible for what part in the book, which is a unique, I think, a unique activity and a unique kind of putting together some information and putting together teaching material. If I'm not mistaken, for students. So, international human rights protection, in my opinion, differs from traditional international law in many ways and covers a wide range of issues. For this reason, it has come to be regarded as a separate discipline, often taught independently of general international law. Accordingly, this section and this part of mine, which is now a kind of introduction to the whole subject, I will provide an overview of the main instruments of international human rights protection and their institutionalized mechanisms. In addition to the development of international human rights protection, the following very short presentation will outline the basis for understanding human rights, characteristics of human rights obligations, and possibilities for limiting them. When discussing human rights, we specifically refer to the protection that international law guarantees individuals, in some cases also groups, through international treaties and other mechanisms. However, it should be emphasized that the idea of limiting the power of the state over the individual is much older than these international legal mechanisms. Almost all states have a catalogue of fundamental rights in their constitutions, at least in letter, that can be enforced in the courts. Human rights are therefore a cross-cutting issue regulated not only by international law, but also and above all by domestic law. Human rights have their foundations in natural law considerations, especially those of rationalism and the Enlightenment. According to Immanuel Kant, they exist a priori, meaning they are inherent from the very beginning. This implies that human rights do not need to be written into positive law to be valid. Every human being is born with them. In practice, it is necessary to regulate and enforce these rights. This first occurred at the national level. For example, they were postulated in the Virginia Declaration of Rights during the American Revolution of 1776 and in the Declaration of Human and Civil Rights during the French Revolution of 1789. Subsequently, they declared the aims of the bourgeois revolution in Europe in 1848. So this is nothing new, I suppose, to all of us. However, international law did not originally prescribe how states should treat their citizens. The assumption was that only the protection of non-citizens and national minorities required regulation at the international level. However, the Second World War demonstrated the need for external regulation, a kind of external regulation and control by states concerning their citizens. Although the League of Nations had already conducted valuable work on the protection of minorities during the interwar period, the development of human rights protections at the international level primarily occurred after 1945. In this context, Article 1, Para 3 of the UN Charter already postulates the promotion of human rights without distinction as to race, sex, language, or religion as an objective of the United Nations. Against this background, the first Universal Declaration of Rights applicable to all human beings was proclaimed on 10 December 1948. Well, we have the 6th December today, so a few days and then we have the Human Rights Day. This was the birth of human rights protection under international law. Subsequently, several international treaties and soft law instruments have been developed at international and regional levels to protect human rights. Some thoughts about the concept and the nature of human rights obligations. International law essentially assumes that individuals are mediatized. Accordingly, the primary addressees of the international legal order are states, while individuals are only indirectly covered by traditional international law. This is particularly evident in the fact that individuals typically depend on their home states for enforcement at the level of international law. The principle of the mediatization of individuals is increasingly, violated in international human rights protection. Individuals are the direct recipients of human rights guarantees and thus become bearers of international rights, in contrast to international criminal law, where obligations are primarily imposed on individuals. In some cases, individuals have even been given the opportunity to enforce their rights directly before international tribunals. Human rights often conflict with state sovereignty and the principle of non-intervention because they dictate how states must treat people within their jurisdiction, including their own citizens. Additionally, applying traditional enforcement methods in international law to human rights treaties is complicated also by the lack of reciprocity. The rights of third parties and individuals are standardized rather than arising from a reciprocal contractual relationship. To ensure compliance with human rights, international protection mechanisms are needed and guaranteed by international organizations and treaty bodies nowadays. According to the principle of the universality of human rights, all human rights are valid everywhere and apply equally to all people. This principle is opposed to the idea of relativism or regionalism. Relativism derives regional and ideological differences in the content and application of human rights from differences in the moral concepts of different cultures or religions. The Vienna Declaration and Programme of Action, adopted by the 171 states present at the 1993 World Conference on Human Rights, states that all human rights are universal, indivisible, and interdependent. It emphasizes that these rights to everyone hold equal value, are interdependent and complementary, and should therefore be implemented as a kind of package. However, this declaration is non-binding soft law. The practices of many states, particularly regarding the so-called Sharia reservations, show relativistic positions regarding respect for human rights, contrary to the idea of universality. A particular problem is the commitment of international organizations to human rights, particularly given their extensive immunities. In most cases, commitment to human rights standards is only given under customary international law. However, bodies such as the United Nations Security Council have no regular reviews or enforcement mechanisms. An exception is the European Union, which has established a comparatively strong internal protection mechanism and is negotiating to submit to external control under the European Convention on Human Rights. Human rights can be roughly divided into 3 generations based on their developments in international law and the debates surrounding them. Although this categorization is simplistic, especially with regard to the historical genesis of individual human rights, it is helpful in better understanding the division of human rights into different treaties. The first generation includes the so-called political and civil rights. These are primarily human rights, which were first enshrined in constitutions as fundamental rights in the 18th and 19th centuries. They limit the power of the state to interfere with the individual and are therefore known as the right of defense. These rights include the right to life, for example, freedom of expression and freedom of religion. At the international legal level, they are primarily found in the 1966 International Covenant on Civil and Political Rights, the ICCPR. In the context of the development of international law related to communism and socialism, the focus was primarily on human rights, where the state was seen as a provider for individuals. This second generation includes economic, social, and cultural rights, also known as entitlement rights. This includes the work, for example, the right to work, education and health, and are primarily codified in the 1966 International Covenant on Economic, Social and Cultural Rights. Conversely, third-generation human rights are applicable to entire groups and are mostly collective rights. In particular, they include the right to self-determination, development, and the use of natural resources. The rights of indigenous people are also collective rights, for example. Initially, it was often assumed that states had different obligations based on their first and second generation rights. In this context, a distinction is also made between substantive and procedural obligations. However, owing to the interdependence of all human rights, this distinction is now considered outdated. It is now assumed that all rights encompass both substantive and procedural obligations. For example, the right to health may include the development and implementation of a program of action to reduce maternal mortality as a duty of conduct, while reducing maternal mortality to a certain internationally defined minimum serves as a duty of outcome. States have a threefold obligation regarding all human rights: the obligation to respect, the obligation to protect, and the obligation to fulfill. In principle, the protection of each right requires the fulfillment of all three obligations, although one obligation may be more pronounced than the others, depending on the nature of the right. The obligation to respect includes the classic prohibition of interference, which prohibits the state from interfering in the sphere of the individual protected by human rights. The obligation to protect requires states to protect individuals from interference with their human rights by third parties. The obligation to fulfill, on the other hand, involves positive measures by states to create the basic conditions for unrestricted exercise of rights by each individual. These usually depend on available resources. Depending on the nature of individual human rights, a distinction must be made between absolute and relative rights. Most rights are relative, allowing for interventions in protected areas as long as they are proportional. A good example of the principle of proportionality is Article 18, Para 3 of the ICCPR, which addresses freedom of thought, conscience, and religion. The specific necessity of a state measure is particularly important, and the least restrictive means must always be chosen. However, for certain human rights, such as the prohibition of genocide, slavery, and torture, no state intervention is permitted at all. Intervention cannot, therefore, be justified in emergency situations by the behavior of the victim of the violation or by the need to protect the rights of third parties. Many human rights can be suspended in exceptional situations, such as war or serious disturbances. Human rights treaties usually contain an emergency clause, such as Article 4 of the ICCPR, for example. However, certain particularly important rights are usually excluded. These are called non-derogable rights. In any case, absolute rights are considered non-derogable, but not all non-derogable rights are absolute. For example, freedom of thought, conscience, and religion cannot be suspended even in a state of emergency, as stipulated by the ICCPR and, for example, the American Convention on Human Rights. However, it should be noted that the emergency clause of the European Convention on Human Rights does not mention these rights. Since the Second World War, institutions for the protection of human rights have been established at both universal and regional levels. At the universal level, the UN has taken on this responsibility, while at the regional level, several human rights treaties and protection mechanisms have been linked to regional international organizations. These include the Council of Europe, European Union, African Union, Organization of the American States. My time is up. I was trying to give you a very short overview, a kind of introduction to the theoretical framework of human rights. paving the way to the more specific presentations focusing on the rights of the child and their protection by international legal instruments. Thank you so much.